Namaskar, dear friends. Welcome to my channel. And here, presently, we are in the series of lectures of Indian Constitution. Today, we are going to see the topic of silent features and characteristics of Indian Constitution. Now, we will describe these points one by one in point-wise manner. So, first of all, we will look after into the meaning of the Constitution. Here, when we are going to see the meaning, uh, I want to quote the meaning defined by Mr. Wade and Phillips, who were in their book has written down related to the constitutional law. According to Mr. Wade and Phillips, constitutional law is that law which describes the structure, power, and functions of the government organs, their relationship with each other, and with the people. Further, this says that it consists of both legal as well as non-legal rules. Here, the formal rules are enforceable by the court of law, while the latter rules are not so enforceable, though they have been accepted as binding by all who are concerned in the government. Now here, the important aspect with reference to the constitution is that the three things which has been explained in this definition. The first one is that our constitution is a document which describes the structure, power, and functions of governmental organs, for example, legislature, executive, and judiciary. Secondly, our constitution speaks about the relationship of governmental organ with each other. And thirdly, it also speaks about the relationship of governmental organ with the people. Now, in this way, we are able to see that our constitution has been described in a particular manner. It has a structure, it has powers and functions regarding the government organ. It is describing the relationship between these governmental organ and uh, with the people as well. So there are certain rules. Some rules are called as in legal rules. Some rules are called as in non-legal rules. The legal rules which has been described, they are enforceable by the law, and whereas the non-legal rules are not enforceable at law. In this way, we are knowing the meaning of the constitution. Secondly, we'll come to the salient features and characteristics of Indian constitution. Here, in total, we are going to look after today 12 points and remaining 11 points in our next lecture. So here I have drawn this 12 points for you. Our Indian Constitution is a comprehensive document. Comprehensive here means that it consists of all the things in a detailed manner, and that is why it is called as comprehensive. So our constitution is the largest and most detailed constitution. Ordinarily, when it has been formed for first time, uh, we are consisting of 395 articles in it, 22 parts, and 8 schedules. Presently, we are having more than 400 plus articles, 24 parts, and 12 schedules. Now, there are certain reasons why our constitution is the bulkiest and most detailed constitution. Now, here are some reasons. Number one, our constitution deals with the organization and structure not only of the central government but also of the state. Secondly, our constitution consisting of detailed norms of center-state relationship. Thirdly, our constitution has reduced to writing the unwritten conventions and detailed procedures. Fourthly, there exist various communities and groups in India. Now, to remove the mutual distrust among them, it was felt necessary that this much laws should be written down in a detailed way. Fifthly, it was also necessary to include in the Constitution the detailed provisions related to the fundamental rights, safeguard to the minorities, scheduled tribes, scheduled castes, and backward classes also. As our Constitution is saying that our Constitution is a secular one. So, provisions related to the minorities, scheduled tribes, scheduled caste, and backward classes should be there. They have been reduced to the writing. Sixthly, for the social welfare, Constitution includes directive principles of state policies. And lastly, beside these fundamental principles, many administrative details are also included in our Constitution. For example, provisions regarding citizenship, official language, government services, elective machinery, etc. So these are some reasons due to which our constitution looks like that it is the bulkiest constitution in the world. Now, secondly, we are having another criteria in our silent feature and characteristics that our Indian constitution is treated to be the modern constitution. Why it is modern constitution? Because it has been drafted in mid 20th century and there are certain features due to which we are calling it as an modern constitution. Our constitution has been prepared due to certain provisions which has been inserted in it from the different part of the world's constitution. We have taken few of the chapters, few of the concept in our constitution. Number one, the provision of the fundamental rights has been taken from United States of America. Secondly, we have taken directive principles of state policy from Ireland. Thirdly, power of judicial review from Supreme Court of USA. Fourth, federal setup with the strong center from Canada. Fifth, residuary power to the center from Canada. Sixth, emergency provisions from German Reich. And finally, seventh, that is parliamentary form of government from United Kingdom. There are a number of such features as well we have taken from different constitution of the world that the good things has been caught hold and they have been inserted in our constitution, and that's why our constitution is said to be the modern constitution of the world. Now, the next characteristics which we are going to see here is the parliamentary form of government. Our constitution is following the parliamentary form of government as we have followed the British model. Indian constitution established a parliamentary form of government both at the center and at the states. Now, the essence of this system is that though the president is the constitutional head of the state, the real power lies with the council of ministers. Further, the council of ministers are collectively responsible to the house of people, that is called as a Lok Sabha according to Article 75 subclause 3. The same pattern has been adopted in the state with some modifications which has been made in by the states. So, in this sense, parliamentary form of government is there. Now, the fourth characteristics which we are going to discuss here is our constitution is a unique blend of rigidity and flexibility. Rigidity and flexibility as it is concerned with the amending power of the constitution. Now, in our constitution, we are having certain provisions which can be get amended. So, in one sense, it is said that the Indian constitution is flexible as well as rigid. Here, related to the amending power of the constitution, the Indian constitution is said to be flexible as well as rigid. Only a few provisions that requires the consent of half of the state legislature and the rest of the provisions can be amended by special majority of the parliament according to Article 368. Now, Sir Ivor Jennings, They have taken a view that Constitution of India is rigid is not correct, as it has been amended 94 times till 2003, and presently we have crossed 100 plus amendments in our constitution, and that is why sometimes it is we are able to say that our constitution is flexible, and sometimes the provisions like article 370 which has been implemented here, we can see the procedure for amendment is a rigid one. So the concept of flexibility and rigidity is the criteria of our constitution as one of the characteristics. Now fifth one is that a federation with the strong center. Indian constitution is looking like just a federal type. So it establishes a dual policy, a two-tier government system with the central government at one level and of the state government at other level. But there are various situations wherein Indian constitution acquires unitary character. For example, emergency provisions are there, appointment of governor, etc. is there, and that is why we can say that our Indian constitution is looks like a federation with the strong center. Now, next characteristics of our constitution is that fundamental rights. Fundamental rights. So, fundamental rights have been explained in our Indian constitution under part third. It, uh, it has been extended from articles 12 to 35, which deal with the fundamental rights. So, all the fundamental rights can be claimed by citizens, while some of them can be claimed by non-citizens also. However, we can say that fundamental rights are not absolute rights, but they are subject to certain reasonable conditions or reasonable restrictions. And here, to protect these rights, Constitution has conferred certain powers on the Supreme Court under Article 32 and on High Court under Article 226. So these all fundamental rights has been given to all the citizens of India, and some of them are claimed by non-citizens as well. Now, after this, we are having a chapter of Directive Principles of State Policies in our Indian Constitution. Now, here, uh, Article 36 to Article 51 describes this part 4th of Indian Constitution, which is dealing with the Directive Principles of State Policies. They are not enforceable in the court of law. According to Article 37, these principles are fundamental in the governance of our country, but they are not enforceable in any court of law. Here, the concept of welfare state is provided in these principles. Now, they lay down certain social, economic, and political objectives to achieve the ideals of the true democracy. So, it is the duty of the state to apply them while making the law. So, directive principles are giving directions to the state to create the policy, to create the law, and utilize that law for a welfare state. Now, our next characteristics is fundamental duties. Fundamental duties. This duties has been added to the Indian Constitution by 42nd Amendment Act 1976. It was as per the recommendations of the Swaran Singh Committee. In all, there are 10 fundamental duties that has been added in the part 4th A, that is Article 15A of the Indian Constitution. Secondly, it shall be the duty of every citizen of India to abide by all the fundamental duties. It is emphasized that these duties should become a part of educational process in the country. For example, presently we are having one subject called as an environmental studies. So this is through the educational process we have been taught Article 51A, that is duties, fundamental duties of Indian Constitution through one subject. Now, the object is to remind the people behind this criteria is that while Constitution confers on them certain fundamental rights, it also requires that the citizen to observe the basic norms of democratic conduct and the behavior as their duty. So, as we are having the rights, that is the fundamental rights, fundamental duties are also that much necessary for each and every individual. Now, our next characteristics is that distribution of legislative power. Now, here powers are distributed at different level, that is at the central as well as at the state level. So, the Indian Constitution contains three lists under 7th schedule by which distribution of legislative power between union and state has been given. The first one is that union list, which contains 97 subjects, and parliament has exclusive power to make laws with reference to these. Secondly, the state list consists of 66 subjects, and legislature of any state has exclusive power to make laws with respect to any of these subjects. Thirdly, there is one more list called as an concurrent list, which contains 47 subjects, wherein the parliament and legislature of any state both have the power to make laws with respect to any of these subjects, but subject to certain conditions. If law made by the state is in conflict with the law made by the union, then in such condition, law made by the parliament will be prevailed. So, in this way, the legislative powers has been get distributed amongst state and union. Now, the next point is or characteristics is concerned with uniformity in all basic matters. So, we'll see here 2-3 points related to it. The Indian Constitution adopts three means to maintain administrative and legislative unity in the country. On the basis of the entire legal and political system in India, it is governed visible by three ways. Number one, we are having a single judiciary. We are having fundamental laws uniformly as concerned with the civil laws or criminal laws, whatever be the case may be. And thirdly, common to all Indian services. So all services are provided to each and every individual in a uniform manner. The next characteristics is independent judiciary. Indian Constitution has given certain provisions to maintain the independent judiciary in India. There are certain principles which are intended to secure the independence and impartiality of the Supreme Court and High Courts in India. We will see here certain reasons why this is independent. Now, here the court system or whatever judicial system we are having, uh, it is impartial and it is independent. Why? There are certain reasons. Number one, appointment of judges by the president after consultation with the judicial authority. Secondly, security of the tenure is guaranteed to every judge. Thirdly, their salaries are fixed and they cannot be varied by the legislature except during the period of proclamation of emergency. That is, during the financial emergency according to Article 360. Once appointed, their privileges, rights and allowances cannot be altered to their disadvantage. Fifthly, Supreme Court and High Court can recruit their own staff and frame rules regarding conditions of the services. Nextly, the salaries and allowances of judges are not put to vote of legislature. It means that in parliament, uh, it is not going to get discussed regarding the salary and allowances of the judges. Neither they can put vote for the salaries and allowances of the judges. Further, the Constitution bars the judges of Supreme Court from pleading or appearing before any court or judicial authority in India after their retirement. And lastly, no discussion can take place in the legislature of a state or in Parliament with respect to the conduct of any judge of Supreme Court or High Court in discharge of their duties. So, in this way, there are certain criteria due to which our judiciary is independent. Next characteristics is amending process. As earlier we have discussed that under Article 368, the process of amendment is going on. So, our Constitution provides for amendment of the Constitution in accordance with the procedure laid down under Article 368. Under Article 368, an amendment to the Constitution may be initiated by the introduction of the bill in either House of Parliament. After that, it shall be presented to the President of India, who shall give his assent to that bill. And after receiving the assent of the President, the Constitution stands amended. So, till this, we have seen 12 characteristics and salient features of Indian Constitution. The remaining 11 we will see in our next lecture.